Hello, everyone. It is so wonderful to be here with you on this glorious Thursday afternoon. And my name is Mayra Cuevas. I am a member of Las Musas, a collective of Latina authors. And I am also the author of Salty Bittersweet, a YA foodie rom-com that has gotten a lot of great accolades. And it's been chosen for a bunch of books to read in 2020 list. So I'm super proud of my little rom-com. It's out there in the world. And I'm here with my friend and also Atlanta author, Gilly Segal. She's the co-author of the NAACP Image Award nominated YA novel, I'm Not Dying With You Tonight. I love that book. It's awesome, awesome read. Yeah. And the chief legal officer and at Atlanta Ad Advertising Agency. She specializes in advertising and digital and social media, intellectual property, and technology transactions, including software and internet licensing agreements, online content transactions, sponsorship agreements, web-based service agreements, and publishing and marketing. So the woman is incredibly freaking smart. She's here today. Welcome.
Thank you.
I'm so forward to talking to you.
Thank you. I'm so appreciative to Las Musas for having me.
And if you're, please let us know where you're joining us from. Go to the chat box. Go to the chat box and just put in, hey, where you're logging in from. And we'd love to hear from you. We're also going to be answering your questions as we're going through. I have some questions for Gilly that how we structure the webinar, but we also would love to hear your questions. So please let us know, put them in the chat box, and we'll get started. So Gilly, let's talk about contracts. Yeah. Do I need a contract with my agent, publishing house, beta readers? And for those of you who don't know what beta readers are, so they are the people that read your manuscript either before it goes to your agent or before it goes to your editor once you're a published author. So these are people who are part of a writing group or people that that are part of critique groups, either in person or online, and are giving you feedback. So what are some of the common publishing contracts and how do you engage in them?
Yes, so I will absolutely answer that question. It's my favorite thing to talk about because I'm a super big contract nerd. But the first thing I have to say, because I'm a lawyer, this is my legal ethical obligation, is to remind you guys that while I am a lawyer, I am not your lawyer. Here it is on screen. And so I get to ask these questions all the time, right? By friends or people who want to post hypotheticals. And I have to be a little bit careful about not forming attorney-client relationships outside of the scope of what I do for my day job. So I can provide all this information kind of as a general informational webinar. But if you are looking for very specific legal advice from an attorney who represents you, I would recommend that you reach out to a lawyer who you can hire. And we'll talk a little bit later on about some low cost and pro bono resources that I can recommend for you guys to hire. So that's like my big old disclaimer. But let's talk about contracts. I'm a super big contract nerd. It was my favorite class in law school. I thought I was going to like love the litigation stuff, but no, I really like contracts. And the reason I like contracts is because they are the story of your relationship, right? We think of them as legalese. We think of them as terms and conditions, but really it's a document that describes how two parties are going to accomplish something together. And anytime you're telling a story, you could have an oral story, but then maybe when you go to try to remember what that story said, someone remembers it a little bit differently. And that's why I always say, yes, anytime you're entering into a business transaction in the publishing space, you should have a written contract that describes the rights and responsibilities of the parties, who does what, who's responsible for what, who pays what. And then everybody's literally on the same page about what you're agreeing to. So if you are an agented writer or you're an author who's a writer who's seeking representation from an agent, there should be a contract in place with your agent. Now, Exactly how much gets detailed in those contracts is a business decision, right? So some agency contracts are kind of one-page documents that set forth the high-level basics, and some are 10, 15, 20-page complex documents that describe lots of different things. And how much you are comfortable with being general versus how much you're comfortable being specific is up to you. But there are some minimum basics that an agency contract should contain. Obviously, what they're doing for you. What is it you're expecting your agent to do for you? Typically, that's going to be pitching your work to publishers, negotiating your contracts, and managing your payments and royalties. It should describe what work the agent is representing you for. Some agents are generalists and they can represent your adult fiction, they can represent your young adult fiction, they can represent a variety of different things. Some agents are specialists, right? You might have an agent that specializes only in young adult, and they might say to you, well, I'll only rep your young adult work. If you want to pitch for the adult market, you're going to have to find another agent that does that. If you are also an academic, right? If your day job happens to be as an academic, you would want to be clear about whether the agent's expecting to represent your academic work. I would say that's probably a little more rare. Agents that are for the commercial market may not have as much experience with the academic market, so you would just want to make sure your contract's clear about that. What else do you have in an agency relationship? Money, right? Contracts that involve the exchange of funds, you're always going to want to be clear about money. The traditional agency relationship involves an agent taking a commission, a percentage of your advances and your royalties. So you're going to want to understand what percentage is it? What does it apply to? Does it apply to sub rights, movie rights, film, other types of licensing rights or not? If they engage in foreign rights sales for you. Oh, yes.
So is it important? I mean, when you get, you're so excited when you get a representation agreement from an agency, right? Do you think it's important to run that contract through an attorney that you trust first, or ask questions as if you're not sure what certain things mean and push back if you're not comfortable with something in that contract?
100% yes to understanding and asking questions. I can't tell you how many times an author meets me and says, I didn't really understand this agency contract, but I signed it anyway. Or my worst nightmare, I didn't read this before I signed it, right? So then absolutely 100% across the board, do not sign a contract that you have not read and don't understand. Now, you can agree to all sorts of good, bad, negative, indifferent business terms. That's a personal decision that you make. The number one thing I would say is if there are terms in your agency contract that you don't understand, ask your agent about them. One of the things that your agent will be doing is negotiating contracts on your behalf. They should have a solid understanding of what contractual terms mean. Now, in that case, you're sort of parties across the table from each other negotiating to go into a relationship. So if you have concerns about something that you're being told, still don't understand it, absolutely run it past a lawyer. The Authors Guild is a great resource to have agency contracts reviewed, by the way, if you're a member of the Authors Guild. But yeah, don't ever enter into a contract that you don't understand, because then it will come back to.
So are there some red flags?
Yeah.
Do you feel like there's some things in it that are some red flags that you should be looking at?
Absolutely. One clear red flag is if the agent would be things that the agent's asking you to pay for, right? At the moment, it is not typical for a traditional agent who earns their money off of commission to ask you to pay for things other than standard costs, right? So for example, an agent might pass through the costs of shipping to you if they're shipping out copies of your books and things like that. But you know, it's not typical in my experience that an agent would ask that you pay for their editorial time. That is typically part of the service that they're investing in you in order to sell your book, and then they make their money off of the commission. So that would be an example. Another provision that I have seen occasionally is how long does an agent claim rights in the work that they've worked with you on? So for example, it's very typical, completely standard in fact, that if an agent sold your book and you part ways with that agent and go work with another agent, the agent who sold it will still be earning commission off of your royalties on that book. They did the work to sell it. It's only fair that they should get to earn money off of it. Sometimes you will see an agency saying that if they have given you any editorial feedback on a book, but ultimately don't sell it, they still have rights in the work that they provided editorial feedback on. I think that's a little bit less of a common term. It's one that would give me personally a little bit of pause. If
Yes.
they didn't manage to
Yes.
sell the book, it's unclear to me why they would continue to earn off of it. And it's going to make that project potentially less attractive to another agent who would be taking a reduced commission on it. So that's one that I would be careful of. Ultimately, it's up to you what you sign with. If your dream agent only works under that term and you are otherwise okay with it, you get to make your own call. But it would give me pause.
And I think one important thing in these agency agreements, and Anna has a good question. She says she just got an agreement and not a contract. Is that weird? The terms, I think, are interchangeable sometimes. Some of agencies call the representation agreement, other ones call them representation contracts. But I think one of the most important things when we're looking at contracts is like, how do we part ways? If the relationship is not working, how do we end the marriage, right?
Yes.
What's
yes.
the divorce clause?
It's a great question. First of all, Anna, congratulations. It's exciting to be made an offer, and it's a nice validation of your hopes and dreams. So yay. I can't wait to read your work on the shelf someday. But yes, excellent question. And what your contract or agreement, the terms are kind of interchangeable. There isn't a material difference between them. So no, it's not weird that you got something called a contract versus an agreement or vice versa. Now, what you're getting at, Mayra, is a very important point, and that's the term of the agreement. Term is how long does the relationship last? Most agency relationships are what's called evergreen relationships, meaning they continue until somebody terminates them. And that's perfectly fine. There are some agency relationships, contracts you will see say, this is for the sale of one manuscript and one manuscript only, and we'll renegotiate if we want to work with you more. That's also fine if that's the relationship you want to have. But regardless of how long your term is, all contracts should deal with how you terminate the relationship. How do you part ways and what happens if you do? So it would be pretty typical to say that you give each other formal written notice, right, of some amount of time, 30 days, 60 days, 90 days. And it would also be very typical that it would spell out what happens in that case. Again, it's extremely typical and standard, and again, fine in my opinion, that the agent continues earning commission off of the books that they've sold on your behalf. And then you would want to make sure that you understand what happens to any unsold materials. Are they going to continue handling your royalties? They probably will, and passing them through to you. Any unexploited sub-rights probably will stay with the agency that sold the work. So those are the kind of things you want to make sure you understand and part ways. Now that's the legal answer. The relationship and emotional answer is a little bit different, right? I'm the kind of the lawyer that likes to say, I can tell you the legal answer, but there's also a relationship at stake here. An agency relationship is a business relationship. Hopefully it's a good one and a positive one. Sometimes they don't work out. If you're having issues with your agent, talk to them. And if you can't talk to your agent, ask yourself why you feel uncomfortable, right? So I'm a lawyer in this area. My very first resource when I have questions about my contracts, questions about what's going on, is still my agent, right? She negotiates this stuff for a living. And I feel 100% confident and comfortable asking her any question that I need to. If we were having issues, I would also feel comfortable saying to her, hey, this particular thing isn't working for me. Can we talk about it? So my first recommendation before you just up and part ways with somebody is to ask yourself, is there a fix possible here?
Mm-hmm. Yes. So Anna just mentioned in the comments, she says that there's no contractual terms in the agreement. It's just that I agree to work with you kind of thing. Okay, and if you could give us a little bit more detail if this is like a literary agent that you're working on, because it's just most of us usually do get an agreement, even if it's called an agreement. There's still a contract that you have to sign with very specific terms. So Christine has a question. My agent sold a book, and my contract includes an option. Congratulations, that is awesome. I've since parted ways with my agent, and she claims she gets a commission on the book, on the option book, if it sells. Do you know if that is standard? That the contract doesn't address this specifically? That is a great question. And she says, to clarify, my publishing contract includes an option of my next book. My agency contract is silent on this issue.
That's a tough one. And that's probably one where I would have to refer you to a lawyer who's going to be able to look at the documents. and see if there's anything, because there's express contractual terms and there's implied ones. And so I would say that's the kind of situation. I don't always say you need to go to a lawyer for every contract. That's one where I would say you probably want to, it's worth spending a little bit of your time and money talking with someone who can read these documents for you and help you make your best case. I'm sorry, I know that's not.
Chrissy, we're going to have some, I know, but I mean, some stuff you just have to take it to your own attorney that can look at the devil is in the details, as they say, right? In contracts. And we're going to have, yes. And we're going to have, at the end of the webinar, we're going to have a slide with some resources that are pro bono resources for writers and authors that you can go to. So let's talk very briefly about contracts for beta readers, because I also want to check on contracts when you're co-writing a book.
Yes. So let's talk about beta readers first. This, I would say, is not a very common thing in the industry yet when you're just asking for someone to beta read your book. So if I go to Mayra and I say, I'm working on this mystery, which I'm going to send you to beta read for me, by the way. I'm just asking her as a friend for feedback on my work. I know Mayra and I trust her, and I know that she's not going to send that manuscript out to somebody else and share it that way. So it's a little bit uncommon to ask an average beta reader for a contractual relationship. Now, that's not to say that you couldn't, but I would be much more likely in that case, personally, to put it in an email what I'm asking of her and to remind her that it's not public yet, and so please keep it to herself. Now, the more serious you're getting with these relationships, like if you're hiring a sensitivity reader for pay, again, you've got an exchange of funds there, you've got a business relationship, maybe it does make a little more sense to have a contract in place with them. I would still say it's not terribly common yet. It's much more common to have an exchange of emails, which, by the way, you can form a contract without signing a piece of paper, right? All you need to form a contract is an offer, an acceptance, and an exchange of value. So if you by email say, if I say, Mayra, can you please beta read this book for me? And I'm going to pay you $250 because we should be paying our sensitivity readers. And you reply back and say, yes, I will do it. We have a contract now. We had an offer, we had an acceptance, and we have an exchange of value. So I don't know that formal documents that people are signing are common, but offer and exchange via email is. And you should be clear about what you're asking of them, right? Like number one is, especially if you're asking for a sensitivity read, I'm an advocate that you should be paying your sensitivity reader or exchanging value in kind, right? If someone is agreeing to read for you and what they want is for you to read for them. Go ahead.
And ideally, to be in the contract when you're trying to sign a publisher, you can ask that the publisher pay for the sensitivity reader. At least that was, we hired a sensitivity reader for Salty Bittersweet through Blank HarperCollins, and they actually paid the fees for the sensitivity reader. So that was great. So let's talk about co-writing contracts. I know this is something you have a lot of experience because you co-wrote. I'm not dying with you tonight with my other Atlanta writer friend, Kimberly Jones, was fabulous.
Yes.
So you guys have a lot of experience with this. So tell us, what was your experience with the co-writing contract?
Yep. Yeah. Are co-writing contracts common? I don't know. Should they be? In my opinion, yes. Again, it's a business relationship, and ideally you negotiate the terms of your business. Well, I should take a step back. It depends on what you're co-writing for. If you are co-writing with a friend for your own personal enjoyment and nobody ever intends to or wants to publish this thing and it's just going to live on your hard drive or your shared Google Doc for the rest of your lives, I don't know that you need a contract. That seems a little excessive. But if your goal is publication of this, then there is a business side to writing and publishing, which as authors and creative types, we don't always want to think about, but we should, right? Because that's oftentimes where the biggest disagreements come in. So if your goal is to publish, I would say, yes, you should have a co-author agreement. In some cases, a publisher might require you have a co-author agreement. So I'm an advocate of getting these things negotiated on the front end. And it should cover a variety of different things, right? It should cover, again, money. How are you splitting your advance and your royalties if you get them? Is it 50-50? Did someone contribute more to the project? What would happen if you guys parted ways as co-authors and there was the possibility for a sequel with the book? Does one person get to have could one person continue on with the project after the other has departed? How are you guys going to work together? It's a good opportunity to talk about that. And there are forms that you can look at online. I'm never an advocate of copying and pasting a form from online. All contracts should be custom for the project that you guys are working on and the needs that you have. But looking at a form online as a sample to get you thinking about the types of terms that are in there and the questions you want to ask each other is not a bad idea.
Okay, wonderful. And Alyssa actually says it's been answered, had a question about co-author agreement. So basically, and this is becoming very common now, like people write a book together. Like I'm right now, I'm on submission with a co-authored book. So it's just basically you worked on something together and then you're going out on submission. And it's getting super complicated because we got two authors and two agents who are working those. It's a little bit insane, but hopefully we'll hear about something soon.
Yeah.
So let's talk about some of the trademark issues. So can my characters wear brand? And pretty much everybody that has joined today writes fiction. So okay. they're all fiction writers.
Good. Yeah, this is one of my favorite questions to answer, and I get asked it a lot, right? So is my character allowed to have dinner at McDonald's? Can my character wear Chucks? Can they be a fan of Ariana Grande? And the answer is typically, it kind of depends on how you're using those trademarks in your book. If it is very casual, very occasional use of a brand name to refer to the actual item, then it's not trademark infringement. Trademarks protect the source of goods or services so that consumers don't get confused. So if I open up a book and I read that X character on page 57 ate dinner at McDonald's, I'm not likely to be confused about what the source or origin of those goods is. So we call that de minimis use in the law. And it's referring to the actual product, not typically a problem. What you are more likely to get into issues with is if the brand is a massive part of your story, or if the brand has agency itself in your story. It's almost a character. An example of this is typically from John Green's The Fault in Our Stars, right? He has the Genie Foundation. It's probably something like the Make-A-Wish Foundation. But in that case, the Genie Foundation has a really big part of the story, right? And that's where you start to have to worry about, are people reading this book and think that Make-A-Wish sponsored this or is involved in this project in some way? And if the answer to that question is yes, they might, you want to come up with a fake version of it. And you want to be careful about making it too exact to the real thing. Another good example of this is the whole series of Disney After Dark books. Their Disney is such an extremely big part of the books that the average reader probably would think Disney had something to do with the publication of them. And you don't want to create a false claim of sponsorship or endorsement. So if your character is eating at McDonald's on one page halfway through the book, probably not a big deal. If there is a zombie outbreak that happens because of a contaminated McDonald's burger, might also be careful about that, right? Because now you're potentially using a trademark in a disparaging way or creating a negative association with it. And brands, although they don't sue authors all that often, I could imagine if you had the blockbuster book of the year and it made people think that McDonald's was the origin of the zombie plague, they would not be very excited about that. So that's
awesome.
Yeah. And I get this question a lot. Like a lot of us have this question, right? And the question is, do I have to make up a fake name for Walmart every time my character shops at Walmart? Probably not if it's once or twice. But if your character works there and the store is a massive part of it, then yeah, I think your character probably needs to work at Town Mart instead.
So, I mean, in general, it's probably better just to make up your own brands.
That's certainly the easy answer, right? Like you're not going to get sued if you make up Town Mart instead of Walmart. Sure thing. But again, I think the likelihood that you get sued for your character, and I will tell you, like I use brand names in my book. Again, if it's minimal use, if all they're doing is wearing a pair of Chucks on one page, I'm not terribly worried about Chucks suing me for that. So it's sort of what your risk level is, right? If you want to be assured, make up a brand. If you are willing to sort of say this is a very non-offensive, minimal risk, referring to the actual product, probably very low risk thing to do. Now, the other part of this that I often get asked about is song lyrics, right? So can we use brand names? That's a pretty easy answer. Probably not high risk, depending on how you use it. Song lyrics are much higher.
I want to clarify, like once books are published.
Oh, go ahead. Mm-hmm.
Why are song lyrics higher risk?
So they're subject to a different type of protection. Trademark is what we're talking about when we mean brand names. Song lyrics are subject to copyright protection. And if you reproduce a piece of copyrighted material in your work, it is copyright infringement. Even if you're using it to refer to the actual song, even if it's in a complimentary way. Songs are relatively short, so even just a couple of lines of them could really get at the heart of the work. And so my typical answer when it comes to song lyrics or quotations from other books and things like that is you can do that with permission. And oftentimes it's going to include a payment as well. So that's something I always warn people to look out for, is if you're taking the heart of a copyrighted work, course of a song, something like that, the creator of that content is entitled to be recognized and compensated for their work. So get those with permission. Now, that's something else that your publisher may or may not help you with, right? Some publishers will help you clear in the intellectual property world. We call that clearance, right? Finding out who the owner of material is and obtaining their permission to use it. Your publisher may help you clear quotations, epitaph at the beginning of your book, those types of things.
So Lisa had a question going back to contracts. So I actually have an anthology, a story coming out in the fall as part of an anthology called Foreshadow, The Magic of Reading and Writing YA. And I did have to sign a contract for that. So if you are getting published as part of an anthology, yes, you still get a publishing contract. A question from Keith. He says, I have a question about trademark content with brands. I have completed a novel ready for self-publication that takes place in a real and currently operating amusement park set during a specific historical time period. The main character of the novel is a fictionalized low-level employee of the park, and the plot is fiction. The rights, locations, and operations of how the park existed are portrayed and timeline accurately. There's a significant amount of information describing the park. So there's a combination and commentary on this park and a company that still currently exists, as well as things that no longer exist, like hotels, rides, which have been torn down. Do I have libel concerns describing and setting action at either no longer existing places or currently existing elements?
So this is,
and then he says specifically the descriptions could be perceived as negative of the park. Example, cheap hotel turned down.
Yeah, I think you've kind of answered your own question. I think you've kind of answered your own question there. This is a really specific one. And again, I would say you probably want to consult with a lawyer who can actually read the text for you and give you specific advice based on the material itself, because it's all very fact dependent. But in the way that you phrase the question, it suggests to me that you're worried, and I'm not sure you're wrong to be worried in that case. Again, it also sort of sounds like one of those situations where the setting is a character in and of itself, and maybe it has some agency in the story. And so that one would be, if I were you, I would be calling a lawyer and getting some feedback on that. And pardon me, the frame for just 1 minute. I just realized.
Colleen also asked a question. Can someone? Okay, we'll be back here with some awesome questions from.
Sorry, I'm here.
Everybody.
Do you have some more questions?
Yeah. So ladies asking, can someone include another title by an unrelated author in title or marketing? For example, picture book with a tagline, "The 5 Love Languages for Kids."
The five.
Can someone include another title of an unrelated author book in their title or marketing? For example, picture book with a tagline, "The 5 Love Languages for Kids."
Yes. So this is an interesting question. And it's a
So I mean, it's my understanding that the titles of the books cannot be copyrighted. Is that right?
That's correct. The title of a book cannot be copyrighted as the title of a book. However, if, especially with nonfiction, if the author has created a brand out of their nonfiction work, it can sometimes be subject to trademark protection. So in this case, I would say that's something you want to look into further, right? Is the only protection that the author claims in the 5 love languages copyright protection, or might they also have created a brand that now sells merchandise, or that does speaking engagements, or that does some other things? So that's one that, even though copyright is not available in titles, there are other considerations that you're going to want to look into with that.
Okay, so Shay's asking, so if a bunch of places unrelated and not a chain have the same name, for example, Bloom Room, would it violate anything if a character worked at a made-up Bloom Room store?
That's a pretty common and generic phrase, right? So what you're getting to is all of these stores, or whatever they are, happen to exist, coexist in the marketplace. That suggests that they're I'm not sure if we're still on air or not.
Hi, sorry about that. My internet just crapped out and kicked me out of the room. I don't know why.
I have a rule in this era: nobody has to apologize for technical difficulties, for kids and dogs and cats interrupting. This is just the way we work now, so no apologies.
And I apologize if you were in the last like 8 questions, they all got erased from my chat. So if you don't mind putting them back in, if you were like in the group of last 8, that would be great. Because I completely lost my entire chat history when that went.
I might be able to. I can see the chats. I might be able to see some of them. So, okay, so we had a question about it. Let's say that there are a bunch of different unrelated stores called the Blue Room. Can I have my character work at a made-up fictional Blue Room? So what you're getting at is whether and how strong trademark protection is. So if these stores are all managing to coexist without infringing on each other's trademarks as the Blue Room, either they're selling really different goods and services and consumers aren't likely to confuse them, or their trademarks in those terms just aren't very strong because it's pretty common and it's very generic. So in that case, the likelihood of having a made-up store where your character works that's called the Blue Room is probably pretty low, right? Trademark doesn't mean that you get to pull words out of the English language for all intents and purposes. It just means you can't confuse consumers about the source of origin of goods and services. Now, again, if your made-up Blue Room happened to really specifically coincide with one of those existing Blue Rooms, you might find yourself in a little stickier situation. So it's just one that I would say be careful about. So, if you're in a position to say this is really wildly different from what's out there in the marketplace and it's obviously made up and I'm not worried about it, that's fine. But if there's an existing Blue Room that sells, I don't know, high-end flowers, and your character works in a Blue Room that sells high-end flowers, now maybe it's starting to seem a little less coincidental and a little more like it's a copy.
So going back to the lyrics, Carrie has a good question. She's asking, so I have heard that you can refer to lyrics, like instead of hearing "in the pale moonlight," one could say the lyrics of the song filter through the room whispering words of pale moonlight. Is that clear for you?
So
Thank you for reposting, Gary. If folks could repost their questions again, I would really appreciate it.
Yeah, so I would say the lawyers are very careful about using the words quote unquote clear to use. We say things are high risk or low risk because until a court decides, nobody really knows the answer for sure. What I can say is it's certainly lower risk to use a descriptor for song lyrics than it is to actually print the song lyrics. Depending on how close the description gets to the actual words of the song, you might still be in trouble, right? So if your description happens to include basically the words of the song, just couching around it a few other words isn't going to save you from copyright infringement. So that's one that could be a lower risk way to proceed, but you'd have to be really cautious about it.
And Emily's asking, can you use the name of a TV show or song? The name.
Yes, again, that's a lot like using, if you're using it to refer to the brand, the actual brand, if you're using it to refer to the actual song or the actual TV show, and it's in a kind of a non-offensive, non-derogatory manner, I think the risk of someone getting upset and suing about that is relatively low. You know, again, if your character is obsessed with Ariana Grande and she's takes on a life of her own, is in every single page of your book, now I think you might need to be a little bit more concerned that people think Ariana Grande has an association with that. Because the other thing we haven't really gotten into yet is invasion of privacy, right? So we've talked about trademark, we've talked about copyright. When it comes to real people, now you have to worry about things like slander and libel and defamation and invasion of privacy, and those are stickier issues to work through. They're also a little bit outside of my typical area of law. So what I would say is if you have questions about referring to real people, you should definitely find a lawyer who specializes in defamation.
So we had this conversation, Gilly, because the book that's in submission right now that I'm co-writing with Marie is based on something that happened in real life. There's an article published in the New York Times a few years ago about this. But we didn't include any names. We changed the location. We didn't include the name of the school, and we only used certain like events that happen as part of the plot.
Yeah. So, and that's okay, right? So there isn't anybody out there who owns an event necessarily. If you're talking about a certain type of event, there are going to be common items that occur, right, in that event, right? So Kim and I wrote a book that deals with a riot and a protest. There are going to be police officers in that book. There's going to be some violence in that book. There's going to be things getting thrown in that book. So those are common elements that even though it's ripped from the headlines, it's not really ripping off somebody else's protected material. And it's also not invading anybody's privacy. Now, I would say if what you guys had done was very specifically set out to imitate the person described in the New York Times story. And, you know, that person's name was, I don't know, Carol, and you named her Meryl, and she went to the same school as that character, and she did all the same things as that character. Now you're rising to the level of potentially invading someone's privacy, because it's clearly and obviously an intent to fictionalize a real person, and that gets a little more dicey to do. But if you've just kind of ripped in a story from the headlines and made up your own scenario, I wouldn't be terribly worried about that.
So in that same vein, when we are using moments from our life to write, you know, fiction, basically to fictionalize aspects of our life. So can people, let's say people in our families, come after us and try to sue us for defamation?
Yeah. The answer is always yes. No, I'm sorry. The answer is always yes. Anybody can sue you for anything that they want to. The better question to ask is how likely are they to win? And that's what a lawyer does, right? A lawyer doesn't say, can they sue me for this? We say, how likely are they to win? And again, that gets back to this notion of how closely are you depicting them? Is it false or true? Is it in a positive or a negative light? You know, so take caution. If you're setting out to depict someone in your family who's been really awful to you, they might get mad and sue you. The question is whether they're going to win. I think it's maybe Anne Lamott or someone. This is a favorite quote of my co-author Kim Jones, who often says, if people didn't want me to write about them, they should have been nicer to me. But that's not necessarily a defense in a court of law. So proceed with caution.
Okay, so let's go through some more questions here. Ruth is asking, what if you use bibliographic citation for the song lyrics? Does that make the difference? And cite the songwriter, copyright, etc.
Yes.
And I'm sure I mispronounced that word.
No, you did it perfectly. And this is, I just said a minute ago that lawyers often like to give dicey answers. Maybe, it depends, more likely, less likely. This is one that I can give an easy answer to, and it's not the answer you want to hear, but it's no. Citing the author of a song, citing the copyright holder does not save you from copyright infringement, right? The protection for them is not just in having attribution, it's in actually having the right to determine when and how their material gets reproduced. That's what copyright protects. So that will not save you from an infringement claim. Now, if you have found material that's been published on the web and you look at the license that came with that material and the license says you're permitted to use this as long as you attribute it to me, there you go. That's fine to use. But you have to look at each item that you want to use and what, if any, license comes with that.
Yeah, and in that same line, Carrie has a question. Like, for example, she says, I often see lines of poetry or famous quotes in the front pages of books or at the start of chapters. Is there a place to find out what is public domain and free to use?
Yes, public domain is really, really old stuff, right? So if we're talking about legitimately has fallen into public domain, the current copyright law in the United States is that copyright does not expire for the life of the author plus 70 years. So anything that is recent material is probably not public domain. You know, if you're talking about quotes from Charles Dickens, that's probably public domain, right? So pre-1900 materials are more likely to be public domain. And you would want to look out for that. What else did we ask about public domain? Is there a place to find out? Researching when the material was created. That's how you find out, right? There isn't a database of public domain works. You can search for materials on the U.S. Copyright website, Copyright Office website in the United States. It's a little bit cumbersome to use, and not all works have to be registered in order to have copyright protection. So it's not the definitive source. The better way to figure it out is to research the work. When was it published? Who's the copyright owner? What was the law in effect, right? Because and I'm sorry for the dog barking in the background, at least he's not in here on my lap, which he has done for hours before. But yes, you're going to want to research who has it, what was the law in effect when it was published, because there have been a few laws passed in the US that have kind of clawed material back out of the public domain. So research. And there actually are some groups out there who at relatively low cost can help you research materials. So again, that'll be some of that slide that we present at the very end, is to show you guys what are the resources that you can find that can help you look this stuff up.
Yeah, and the Library of Congress has an amazing resource that you can just email a librarian, ask them everything that you want to know out of a copyrighted material, and they'll email you back. I use them for my day job at CNN all the time.
Oh, that's see, it's a new resource for me too. We have to put that on the slide.
Okay, so let's talk about cover art. Can I use my cover art to make bookmarks, stickers, and other images?
Yes. Yeah, this is a great question. And again, this is going to go back to who owns the art that you used. So if you're a traditionally published author and your publisher is the one who developed your cover, you're going to want to ask them this question. Maybe they have an in-house graphic designer who did it. Maybe they hired an artist. For example, with my own book cover, they actually commissioned an artist to create that illustration. And so I would need to go and ask them, what rights do you, publisher, have, right? Was this a work for hire, meaning you have all the rights in it now and you can give me the right to use it for whatever I want to, or do you have limited rights in it? A lot of times a cover is a mashup of several different images. So they might have a license to the stock photography that they used on your cover, and you would want to ask them, what's the scope of the rights that we have for this? And oftentimes the answer is yes, we have the right for you to use it to make a promotional piece for this particular book. Now, you might not be able to take that book cover and use it for something else, but you might be able to just make promotional materials for your book. So the number one thing is who made your cover, and ask them the question. Now, if you're self-published or considering self-publishing and you're designing your own cover or hiring an artist to design your cover for you, those are things you're going to want to put in your designer contract. You're going to want to say, what am I paying you for? Are you using stock photography? What's the license you're getting in stock photography? And if it's important to you to be able to use this for promotional materials, make sure your contract says, whatever it is, designer, that you give me, you will have obtained enough rights for me to go out and make bookmarks or other things.
Okay, Colleen has a question about image use. What rights do people have over their own image? For example, can you use a photo of a stranger on your book cover that was legally purchased with commercial use rights from the original photographer? How much right does the person in the photo have to not have the image used? I'm guessing the person that is depicted in the photo.
Yeah, sure. And so this is why I'm a contract nerd, you guys, because a lot of stuff comes back to contracts. In general, everybody in the world has some rights of publicity. That's what the legal area that we're talking about is, to protect their own image against commercial use that they don't want to be associated with. Everybody has that. The more famous you are and the more you exploit your persona for your own commercial purposes, the broader and more expensive your protection might be. So celebrities, very broad, very costly rights of publicity. But even I do have rights of publicity. This goes state by state. So to some extent, what you're going to want to look at is the resident. Where is this person a resident of a state? But there might be an easier answer than researching state law for you. And the answer comes from the photographer who took the picture. In order for you, that photographer, have the right to grant you the right to use that person's image on your book cover, they should have what's called a model release. So when they took that person's picture, they will have had the model or the person, whoever is in the picture, sign a document that says what the photographer can do with their image. If it's a good model release intended for commercial purposes, it will say, I agree that my image can be used for commercial purposes. So you're going to want to ask the photographer, do you have model releases and what do they permit you to use? Now, the only other caution that I would have with that is, and by the way, if you get your image from someplace like Getty or iStock or one of the common stock houses online, you ask that same question. Your license will make clear whether there are image model releases or not and what they're permitted for, right? If it's permitted only for editorial use, probably not going to cover you making a commercial use out of it. Covers commercial use, you can use it. The other caveat to that would be, even with a model release, there might be carve-outs to it that say you can't use this for something that would make me uncomfortable for you to use it with. So pornography, right? If what you're writing is erotica and you have an identifiable, recognizable person on the cover and their model release didn't say or said something like this can't be used for any associated with sort of erotica or that type of thing, even though you have model release in place, you might still not have enough rights to use it. So go ask the photographer.
That's all good points. So at what point do you say to yourself, okay, I need to hire an attorney?
How worried are you? That's the answer, right? So I would say it's not all that common for an author who is savvy enough to understand contract terms to have an attorney review their agency agreement or their publishing contract. And if you're agented, your agent should be giving you really good advice about your publishing contract. Although some of them are lawyers, they aren't all, but they all should be experts in understanding publishing contracts. So I would say if you're worried, you should have it done. If you don't understand, you should hire a lawyer and have them give you advice. There are lots of pro bono resources out there that are available to help you. So my answer is always, if you're concerned, get a lawyer, right? They're there to be your advocate. They're there to help you. You can negotiate fee agreements. So for example, if all that you need is help understanding your contract, you could say to them, here's my budget. Can you spend an hour doing this? And so my answer is almost always, if you feel like you want a lawyer's advice, you should have one. If you are in a gray area, some of the questions that we've had here today have been really good examples of it's really fact specific, and you're going to want a lawyer to read your specific contract and tell you what your rights are. So we lost Mayra again, but I'm going to assume that I'm still in the chat.
Am I here? Can you hear me?
Yes.
Okay.
I can hear you, but I can't see you.
You can't see me. Yeah, sorry. This has been acting up. I don't know why.
Yeah.
Okay, so if we have any more questions, please put your questions in the chat box for Gilly. And we're going to go over some examples of places that you can go to get some advice And Gilly, I'm trying to start the presentation, but for some reason it's not working. So if you can go on the slides on your area and see if it will play out for you, that would be great.
I can't. Where do I go to make that happen?
It's on the right side. You're going to see slides. You should see a button that says slide.
Okay.
If you click on that, click start presentation on top of the slide.
Okay. Got it.
And then there's a start green button at the bottom.
Yep.
Okay, and then we should be able to see your slide with the resources where people can go to get pro bono help.
Great. Okay, yeah, so here's a really good list of resources. Number one is, if you're a member of the Authors Guild, which I think is a relatively inexpensive resource per year, they have great articles and great resources where you can find some of this information yourself, including a guide that they publish called the Writer's Legal Guide. And it's actually really great, not just for fiction authors, but for those of you who might be nonfiction authors, because there are lots and lots of different issues that we haven't really gotten into about nonfiction. And through the Authors Guild, if you are a paying member, they will also connect you to lawyers who can do contract review and things like that. So that's a really fabulous resource. My next popular resource is Volunteer Lawyers for the Arts. These are state-by-state organizations where lawyers will volunteer to provide time to do pro bono assistance to artists, including authors. The one that I'm most familiar with is here in Georgia. It's called the Georgia Lawyers for the Arts. There's a very well-known one in New York as well. And then I've also given you a link to the St. Louis Organization of Volunteer Lawyers for the Arts, which has a national breakdown. So you can kind of click through and figure out, is there someone in your state that you could go to? Beyond that, I really love this project called the New Media Rights Project. It is a nonprofit organization that focuses on intellectual property, privacy, and technology. And what they can do for you is low-cost intellectual property legal research, right? So, for example, if you need help figuring out who the owner of a particular quote is, for example, that's something that I dealt with in my book. In our book, there is a quote at the beginning of the book, and I wanted some help researching where the origin of this quote was and who I needed to get permission from. And you can do it via making a contribution to this project, which is kind of a really cool thing. And they're very responsive. So love the New Media Rights Project. Go to your state bar association. Look their website up online. A lot of times they will have links to the pro bono resources that are available in your area. Or if you're a member of another writers guild, Writers Guild of America, some of those sort of more screenwriting guilds oftentimes have access to lawyers and other types of resources like that. And apparently the Library of Congress can help you research things like origin.
Yeah.
Go there.
And I'm trying to send it up as a handout. So I'm trying to open it so everybody can have it.
Yep. And if not, Mayra, you're free to include this list in the next, like, Las Musas newsletter, for example. You could do that.
Yes, and both Gilly and I are on social media on Instagram and Twitter. So if you have any questions, please reach out on social media. We're always available and happy to answer any questions, especially for future published authors. Like, we're all future published authors, so it's awesome. And check out our new I will be talking to agent Cristina Perez, and that's happening Friday, May 29th at noon, because Christina's in London, so we have to make the schedule work for her. And this is an Ask Agent live Q&A session. Christina specializes in sci-fi, fantasy, YA, and middle grade. So bring all your questions. She'd love to answer anything, give you any query tips, how to make your query letter distinct and increase your chances of representation. So join us for that. We also have a plotting webinar coming up in June that should be a lot of fun, and you should be able to get a lot out of it. And if you, as you know, the pandemic, we basically have to cancel all our author events. So that's why everything has moved online. So if you want to support authors, buy the books, leave reviews on the website. We love you when you do that. It's just fantastic. Yep. Thank you so much for joining us. This is all we have for today. And let me see, this didn't upload, but I'll go ahead and post those resources on up on my Twitter page. It's Mayra E. Cuevas. So at Mayra E. Cuevas on Twitter. And I'll go ahead and post that slide with the legal resources. So take care, everyone, and hope you're safe and that your family is doing okay. See you until next time.
Thanks, everybody.
Thank you, Gilly, for coming. Bye.
Bye. Thank you.